Okay. Unless somebody else has a question on that one, we'll go to Justice Krueger, I think, to talk to us about a few cases.
Great. Thank you, Rory, and thank you for all you diehard folks who showed up for this panel today despite the competing programming. I'm going to talk about a complex of cases that have to do with the intersection of federal law and state law, which comes up in a couple of different contexts with some regularity on the U.S. Supreme Court's docket. The first of those cases is a case called Williams versus Pennsylvania, which has to do with the constitutional rules governing judicial disqualification. For many, many years, up until 2009, there were basically two situations in which the court found a due process violation based on a judicial, either actual bias or an objective risk of bias. They were when the judge had a direct financial interest in the outcome of the case, and in a sort of a special sort of setting involving contempt proceedings where the judge had essentially acted as the accuser in addition to the adjudicator in the case. That paradigm was expanded in a fairly important way in 2009 in a case called Caperton versus 18 Massey, which was a civil case in which a state Supreme Court justice who had received a very substantial campaign contribution from the CEO of a civil defendant in a case before the Supreme Court cast a deciding vote, reversing a very substantial judgment against the company. The court, from what you can read from the outside, the court deliberated for quite a bit before it decided to take the case. The case was up at cert conference for a number of weeks before cert was ultimately granted. And when the decision ultimately issued, it was a very closely divided 5-4 decision with Justice Kennedy writing, saying that under the extreme facts of that case, that the due process clause and not just state ethical rules had something to say about the integrity of the judicial system in the context where it was evident from a sort of variety of considerations that a reasonable observer would see that there was a great, objectively speaking, potential for bias as a result of the size of this campaign contribution. What exactly that portended for other situations involving recusal rules was an open question after Caperton. That particular decision uses words like extreme and exceptional on pretty much every other page, and the dissent raised substantial concerns not about the outcome in that particular case, because I think all of the justices on the court found that the facts of the case troubling, but on the court setting itself down a path of increasingly constitutionalizing the recusal rules governing judges. So the extent to which the dissent's concerns would be realized remained an open question. Just how far was the court going to go in expanding the constitutionalization of judicial recusal rules? And Williams versus Pennsylvania is a first and partial answer to that question. The factual setting of the case is this. The Chief Justice of the Pennsylvania Supreme Court had 29 years earlier, before this case came back to the Pennsylvania Supreme Court, been serving as the elected district attorney for Philadelphia, and in that capacity signed an authorization for prosecutors to seek the death penalty against a criminal defendant named Terrence Williams. On post-conviction review, new evidence came to light that prompted Williams to file a state habeas petition raising a Brady claim relating to the failure to turn over evidence that he said would have been material at the sentencing phase because it would have provided grounds for mitigating the sentence. The trial court granted that relief, and on review, the Pennsylvania Supreme Court vacated that judgment, with Justice Castile, now in his capacity as the Chief Justice of the court, participating. His was not the deciding vote. He did write a separate concurrence, but his vote was not necessary to that outcome. And the question was whether or not that constituted a due process violation of the sort that had been issued in Caperton versus 18 Massey. And again, a divided court said that it did, This time, rather than providing a sort of broad standard of the sort that it provided in the Caperton case, it provided a relatively more specific, if not bright line rule. If, as a prosecutor, you have had significant personal involvement in a critical decision in the case, then it violates due process to participate further in the case. Exactly what that means going forward, I think, remains an open question. On the ground, the holding is relatively modest. The majority's holding tracks, as the majority itself emphasized, judicial ethical rules that are already in force in much of the country, and so is not likely to greatly alter judicial behavior. But it again raises questions about the extent to which the court is looking to create a more substantial body of constitutional law that places limits on the ability of judges to hear cases in situations that may create a substantial risk of bias in their decision-making. The other set of federal-state intersection cases that I am going to talk about are cases that are frankly not for the faint of heart, but as the diehards who have come here to this panel, I imagine that this is the right audience to discuss them. They're cases having to do with how federal law characterizes prior state convictions for various purposes, which is a question that has occupied a pretty substantial portion of the court's criminal law and immigration law docket for at least a decade. Under federal law, there are certain consequences that attend having prior convictions for certain offenses defined differently for different provisions of federal law. There are federal sentencing consequences, there are substantive criminal law consequences, there are immigration law consequences. And the court has generally approached all of these questions by using what it's called the categorical approach. Rather than looking at the facts underlying a particular defendant's state conviction, it looks at the elements of the state offense of which that person is convicted and compares it to a generic elements-based definition of the relevant crime under federal law. And if the elements don't match, then the crime doesn't count for purposes of the particular federal consequence at issue. The categorical approach, which originated in 1990 in a case called Taylor versus United States, I think did not generate a great deal of repeat litigation in the Supreme Court for some time, and then the floodgates began to open and open more and open more again. Mathis versus United States is a case that is about the exact same statute and the exact same state crime as Taylor versus United States. It has to do with a federal law called the Armed Career Criminal Act, which is a sentencing law that prescribes a mandatory minimum of 15 years imprisonment for a person who unlawfully possesses a firearm, typically because they have a prior felony conviction, after 3 or more prior convictions for either certain drug crimes or what the law calls violent felonies, which is defined to include burglary as well as certain other crimes. In Taylor versus United States, the court had said that the generic elements of burglary are the unlawful entry of a building or other structure with intent to commit a crime therein. As the years have gone on, it's become increasingly clear that not every state's burglary statute matches up precisely to these generic elements of the crime of burglary. A couple of years ago, in a case called DeCamp versus United States, the court held that the California burglary statute, the no burglary conviction essentially that is entered under the California burglary statute, qualifies as burglary for purposes of this definition because the California burglary law does not have as an element the unlawful entry into the building being burgled. So the California burglary statute on its face is broad enough to cover, say, shoplifting or another fact pattern that doesn't comport with the court's understanding of what generic burglary is. Mathis versus United States is the latest entry in this line, and it concerns the Iowa burglary statute, which, again, like many states' laws, covers not just burglary of buildings or other similar structures, but also air and water vehicles. So one can burgle a boat under the Iowa law. And the question was whether or not the categorical approach permits courts to look at the fact that a state has charged, a state that prescribes burglary of a larger number of places than generic federal burglary has charged only one of the possible set of enumerated places that could be burgled in the charging documents, and can rely on that in determining that the defendant had committed what is generic burglary for purposes of federal law. And the court held that it could not. It said it couldn't for 3 reasons. One is because the text of the Armed Career Criminal Act requires a very strict elements-based approach, and that precludes relying on alternative means of committing the same crime. The second is that constitutional avoidance principles dictate that result, because to hold that a court can rely on one alternative means of committing the same crime rather than another would be to permit or would at least raise significant questions under the Sixth Amendment in terms of taking disputed facts necessary to the imposition of a particular sentence out of the hands of the jury and placing it in the hands of the judge. And the third is a set of fairness considerations, that in guilty pleas in particular, defendants simply may not have enough incentive to challenge the kinds of factual suppositions that often get recorded in the documents underlying their conviction, which don't become particularly relevant to them until some years later when there's a federal proceeding afoot. The most interesting aspect of Mathis versus United States is the division on the court that it produced. The categorical approach has been the uniform approach the court has taken to these questions of how to characterize prior convictions for quite some time. And it is clear from the many opinions filed in this case that there's an increasing sense that the categorical approach simply isn't working as intended. As Rory mentioned, Justice Alito filed a dissent that is indeed well worth reading for sheer entertainment value. It begins with the tale of a woman who was driving from her home 38 miles south of Brussels to pick up a friend at the Brussels train station, programmed her destination into the GPS, and days later found herself in Zagreb before she realized that something had gone very wrong. And he compares the course of the U.S. Supreme Court's jurisprudence on the categorical approach to the path to Zagreb. There are some other high points too, so don't just take my summary. But there is also, so in Justice Alito's dissent, there is just a sense that, in sort of taking the categorical approach to this end, the court has effectively eviscerated Congress's instruction to impose a particular sentence for people who had committed burglary, and that this is just not a workable approach that effectuates Congress's intent. And in addition to Justice Alito's voice, which has been fairly consistent on this theme in various cases that have raised similar questions in the past few years, there are, interestingly, also calls from Justice Kennedy, who concurred in the court's decision, but also made an explicit call for Congress to take a look at this issue and see if it can figure out something better. And some notes of concern from Justice Breyer and Justice Ginsburg, also in dissent, who raised some similar questions as Justice Alito about the practicality of taking the categorical approach to reach this particular result. The calls for congressional action are interesting in part because they raise squarely a question that the court has not yet addressed squarely, which is whether or not this particular approach is not just a matter of statutory interpretation, but is indeed compelled by the Sixth Amendment. And that may be a question that we see teed up more clearly in the years to come.
Leondra, if I could just say one thing about this Mathis case. I mean, Justice Alito's dissent is, how do you make this interesting to anybody? Because it's deadeningly complex and dry. So I think he took a tack to do that and succeeded, at least, in drawing our attention to it. The other thing that's going on here, and this is a more difficult question because it's really a political legislative question, is hostility towards mandatory minimum sentences. The impact of this statute is to impose a 15-year mandatorily minimum term of imprisonment. And with the concerns in recent years of mass incarceration statistics and people serving too long for too minor crimes, the idea that you would put people in jail for that length of time based on nonviolent burglaries is a disturbing idea. Now, the statute says that you have to. So what you have here really is a debate about how are we going to find ways, frankly, to get around a policy we don't like. And so applying the categorical approach in kind of a rigid way and then saying, well, most state burglaries won't fit is a way of doing that. Much like, frankly, in my opinion, Apprendi was a way of saying we don't like sentencing guidelines and mandatory minimums, so we're going to find a way to make them discretionary. Again, Justice Kennedy says, if the legislature doesn't act, we might have to reconsider this approach, which is a sort of almost a Pollyanna-ish hope that Congress will take this up and soften the penalties for people under mandatory minimums. I mean, and we can only hope that Justice Kennedy lives long enough to push that through after Congress fails to act over the next 5 years, which would be my prediction. Brian, did you have something you wanted? Just use the mic if you can. I think they record these.
Just one observation that may, inform some of the approach by the Supreme Court in this. The application of the armed career criminal applies as a matter of law. So if the prosecutor brings a case and in other circumstances to obtain the enhanced penalties or to obtain mandatory minimum sentences, the government has to officially allege factors that will invoke the mandatory minimum. Not true with the Armed Career Criminal Act. If we bring a case against an individual and he or she has qualifying prior convictions, they get 15 years, and neither the judge nor the government has any discretion with respect to it.
Great. Sorry to interrupt.
No, not at all. It's actually, sort of the next case I'm going to talk about is Voisine versus the United States, which is actually an interesting contrast with the line of Armed Career Criminal Act cases. It's about a separate subsection of the same criminal statute. It's section 922 G9 as opposed to G1 of Title 18 of the United States Code, which makes it a federal offense to possess a firearm after having been convicted of a misdemeanor crime of domestic violence. And the court has considered a number of questions that have arisen about how to characterize prior assault and battery, typically convictions for purposes of that federal criminal statute over the course of the past several years. And in each of them, the government has won, which is a marked contrast to the Armed Career Criminal Act cases. And a really central part of the court's reasoning in each one of these cases has been looking at the practical consequences of reading the statute any other way. So this particular case was about whether or not a state statute that makes it a crime to intentionally, knowingly, or recklessly cause bodily injury to another person counts as a misdemeanor crime of domestic violence, where that term is defined as needing to have a use of force element. And the word use plays a central role in the court's analysis, and it's a question that has been raised in other contexts, in other federal crime of violence statutes in particular, whether or not the word use, which the court has previously said connotes active employment of force, whether that includes reckless conduct. And the court here says that it does, and it begins with, as you would expect, with a textual analysis of the word use and an explication that is, I think, probably very useful of exactly what the reckless state of mind that the state statute refers to, what exactly that means. But an important component of its analysis is also that to say that reckless conduct does not qualify for purposes of the statute would mean that this federal statute would just have no application in about 35 states in the country, because that's how many states have a recklessness component to their misdemeanor assault and battery laws. And in this case, as in previous cases concerning this federal statute, the court has been very reluctant to apply this kind of categorical approach in a way that would undermine the application of this domestic violence law. As Rory says, one thing that's particularly notable about this case is Justice Thomas's voice in it. He was one of two dissenters. Interestingly, he was joined by Justice Sotomayor, which is not an alignment that you see very often. She joined his analysis on sort of the issue that was actually presented in the case. And the concern that he raised and in which she joined was that the court's approach was overbroad, that it would make it a criminal offense to possess a firearm after committing a crime that may not have involved domestic violence as we typically think of it, but may have just involved reckless behavior that happened to result in bodily injury to a family member. So, for example, drunk driving, where a domestic partner is injured in the accident. And that forms sort of the central concern. And that overbreadth concern is one that we've seen repeatedly in categorical approach cases, and typically to a different result than the one that the court reached in this case. The final portion of Justice Thomas's dissent is interesting because it reaches out to address an issue that the court specifically did not grant cert to review, which was whether or not application of this statute raised significant Second Amendment concerns insofar as it precludes firearm ownership by somebody who is convicted just of a misdemeanor, not of a felony offense. And that's an issue that's generated a great deal of litigation in the years since Heller, and I think is probably an issue that we can expect to see returning to the court sometime in the future.
Yeah, Justice Thomas asked a very hard question, so you can think about this. Is there a misdemeanor offense where the court would uphold a lifetime ban on speaking or a lifetime ban on publishing? Here, a misdemeanor offense leads to a lifetime ban on firearms possession under the current felon in possession statute. Would you uphold a statute that said lifetime ban for speaking on a misdemeanor conviction for domestic violence assault or something like that? It's a hard question. I don't know the answer. Justice Kennedy, at oral argument, suggested a few instances where misdemeanors lead to very severe consequences, but I'm not sure that they're lifetime bans. So I found if the Second Amendment is going to be taken as seriously as the First, this is a plausible line of inquiry, which you're going to see more of along the way. So, Leondra, is that it for you, or
That is
for now?
okay.
All right, we're going to ask Dennis Riordan to talk about